Well, good afternoon, everybody. I'm delighted to have been invited to speak here, and there's been other sessions today, not necessarily in this bit of the building, that have looked at adjudication. So I'm not especially, as a barrister, arbitrator and adjudicator who practices in construction law, going to retread the ground that other people have done already today, and no doubt in a more polished and skilled way that I can do anyway. I'm just going to offer some thoughts on sustainability and the law, and it's really such a large area that I can only offer you between 5 to 10 bullet point ideas that hopefully, depending on your professional background, may be of some assistance. It is really such an extensive area that it's impossible to cover any one part of it in any meaningful way in 20 minutes or so. So there's just some background detail about me on some of the first slides there, and what I'd suggest to you is that sustainability in a legal sense unsurprisingly follows the lead of other common legal ideas. There is an interplay, or legal ideas within an Irish framework. There's an interplay between national law and EU law, and there's scenarios where people assume a responsibility under sustainability law that they don't have to. In some instances, they assume that responsibility quite correctly, realizing that they may as well assume that responsibility now rather than have it foisted upon them at a later stage. So if we go back 6 months or so to the directive on non-financial reporting in December 2014, depending on the size of your organisation and the degree of in-house legal support and external legal advice that you can rely on, that's not necessarily one of the areas of law where you can say that it does what it says on the tin. You might miss that as being an issue that should concern you in 2017 if you're in a public company which has 500 employees or more. So that's something that's coming down the tracks, but many companies of that size, not all companies, many companies of that size have assumed that responsibility to address in their financial reporting where they're at in terms of addressing sustainability issues. So I've not offered you at this stage, because I'm sure you've heard it already, I've not offered you the classical definition of what sustainability is. I would imagine, as I say, that you would have heard it before today, and you'd have heard it today before you got to hear what I have to offer to you. So sustainability in the classical sense there on the screen is an umbrella term beneath which there are numerous issues that could concern you, and the effect of some of those issues obviously can be to increase the cost of doing business if you're in the construction sector. And the corollary to that point, the related point is if you fail to meet your obligations, whether they be obligations that you have assumed or have been placed on you is that there can be adverse consequences in terms of legal costs, fines, actions grounded in contract law brought against you. So this is a area, to use the unoriginal phrase, that is a hot topic, and it's going to be an area that will continue to concern people, and likely it will concern people in a stronger manner year on year. In a legal sense, allowing for the speed at which the law works, or more correctly often doesn't work, it's relatively new. It can be traced back to the 1960s, so the movements and changes in society that led to that definition, which you have on the screen, that all goes back about 50 years. So in the context of it being across the water, the anniversary of the Magna Carta, if you look at law in that more global sense of going back 800-900 years, 50 years isn't really very long at all. So I move past the definition there of sustainability, and sustainability where you have not assumed a responsibility, in the instance that I spoke about there of the non-financial reporting directive. Sustainability has a number of building blocks in terms of where the legal bases for what you may have to contend with come from. Again, starting in the 1960s, the interplay between European Union law and national law, the classical idea now that where there's a conflict between those two areas of the law, that European Union law will win out, and that European Union law is implemented into national law. So there's such a wide range of legislation in terms of what sustainability encompasses that, as I said earlier at the start of this talk, it's really difficult to talk about any particular statutory basis in Irish law relating to planning or waste management or the Environmental Protection Acts in any detail at all. Working hand in hand with that primary legislation is secondary legislation, such as statutory instruments that is often used to implement those European Union directives, the likes of the landfill directive, the likes of the non-financial reporting directive that I've spoken about, and many of the speakers before me and in other parts of this building today will have stood up their speeches by reference to various legislation. Now, what I can maybe talk in greater detail about in the time available to me is the issue that can help you avoid some of the consequences of attracting a liability on foot of a failure to meet the demands that sustainability can place on you. So I can talk about the ideas of dispute avoidance and dispute resolution. So I've offered you the classical definition a few slides back on what sustainability is. I've told you that it's a really wide ranging idea encompassing many fields. It follows that when some people are dealing with their particular slice of the construction field, that they may not be aware that what they're doing falls within sustainability and can be looked at within a legal context as being an issue within the concept of sustainability and the law. And so to go back to that idea of dispute avoidance. Dispute avoidance is one of those simple ideas that in the day-to-day reality of operating your business or conducting your professional life, people often are unable to take simple, foreseeable steps that can avoid subsequent disputes. So the related idea of dispute resolution is if your dispute avoidance steps are not successful, that you try and find the best strategy to determine the dispute that you have with another party. So everybody is very excited about adjudication, and by the nature of the interplay with the processes that fall on the alternate dispute resolution spectrum, people fall in and out of love with some of those processes. So over the water in England and Wales, they've had, under their Housing Act in 1996 or thereabouts, they've had adjudication for about 20 years. And some people are starting to query whether in certain circumstances it can be a sledgehammer to crack a nut. But the idea that I'd like to leave you with this afternoon is that you have to look at the particular type of dispute that you have, and where possible determine the best dispute resolution method for you, and if you're a professional advisor, where applicable, for your clients. It's unlikely, save for circumstances where in a payment dispute where you're bound to use adjudication and you can't contract out of it, it's unlikely that there's a silver bullet that's universally the best way of resolving a range of disputes. So why might you not wish to go to court and follow the classical method that was used for many, many methods before the 60s and 70s, where people started focusing on alternate dispute resolution, which is quite simply resolving a dispute outside the steps of a court? Why might you look at one of those methods? Classical ideas, you've heard them before, or they're not difficult to understand. Speed, privacy, the idea that you can get a particular person to hear the dispute as an arbitrator, mediator, or conciliator, that you're not going to get assigned a random High Court judge who, in the case of a construction dispute, for the sake of argument, might have practiced as a criminal barrister for 27 years. So the attraction with alternate dispute resolution is obvious, and where the resolution method used is at the harder end of the spectrum, like arbitration, it mirrors litigation, and it can be much more difficult than is the case with mediation or conciliation for the parties to resume or retain a relationship. Mediation or conciliation, a softer process, It won't create a precedent that you can rely on. It's not best suited to determine a black letter law issue over a very technical point, but it can serve the useful human and commercial purpose of not leaving both sides exhausted and beaten down at the end of the process. But because of the fact that it can be much quicker than litigation, it's true to say that generally, whether you're involved in a mediation or conciliation or litigation, it's not going to suit everybody, but the quicker process and the process that is inherently less confrontational, it is easier to recover from. Okay, I've got my 5-minute warning, so I'll try and wrap up. I have the advantage that I'm followed by a break and I'm not followed by another speaker. I promise that I won't go over time, but I have the disadvantage that I'm not at a stand. I can't invite you to come along and tell me how boring I was later, but I do edit a construction law journal, and if it was the case that anybody was interested in writing for that, my email details are on the last slide that I'll put up now. So there, the size of the type there is probably not great, but I'm at adhussey@lawlibrary.ie. So as I say, if it was the case that anybody wanted to write for that journal, I'd be delighted to hear from you. So trying to wrap up quickly, sustainability and the law, relatively new by legal standards. It encompasses a huge range of areas, vast number of statutes and statutory instruments. There's the interplay between EU law and national law. The burden that is placed on people is growing over time. By using a dispute avoidance strategy, by conducting due diligence, by not relying on boilerplate contracts that are emailed around at 5 to 12 at night, you can pick, if you do have a dispute, what the best way of resolving that is for your particular client or for your particular company. By definition, a dispute clause is often the last part of a contract, and therefore it's often the part that is looked at 5 to midnight. And it's often a tautology that if more time was spent on it, it would save trouble in the future. So thanks a lot for your time and your attention. It's possible to get back to me there by way of email, and my compliments to the organisers, and I hope you enjoy the rest of the session. Thank you.